talk about money laundering, and more specifically the dangers of money laundering and inadvertent money laundering. So let me start with a little anecdote, and this anecdote is probably from about 20 years ago. But I had a client. This client was a listing brokerage company. They had a property listed. It had sat for a long time, and along comes a buyer who wants to buy the property. And the buyer wanted to put up earnest money. And I don't remember the exact figure, but for purposes of this discussion, let's just say that the buyer wanted to put up earnest money of $18,000 in cash. Now, there's nothing unusual about that, except that this buyer wanted to put up the $18,000 of earnest money in cash. And my client was smart enough to know that if the buyer handed my client, the real estate broker, $18,000 in cash, and then the broker deposited $18,000 or tried to deposit $18,000 of cash into that brokerage firm's trust account, that it would trigger certain reporting obligations of the bank, something that we call a suspicious activities report. And that suspicious activities report had the potential to cause problems for the buyer. So what my client, in his infinite wisdom, remember I said my client was smart enough to recognize the trigger for the suspicious activities report, but the way my client intended to avoid the suspicious activities report is to deposit the $18,000 in two chunks. And at least the way I remember it, and I'm probably embellishing this a little bit, but what he did is he took, say, $9,000 of that money in his car, drove up to the drive-up window, and made a deposit through the drive-up window of $9,000. His assistant then, in the car right behind him, made a deposit of another $9,000 into the same account. That's obviously was not successful in avoiding the suspicious activities report. In fact, breaking up large sums of money to try and get under the $10,000 figure is called structuring, and is also a violation of the money laundering laws. I can't tell you that my client was criminally prosecuted, but it came to my attention because it came to the attention of his regulatory body, the Division of Real Estate of the state of Colorado, and my client was disciplined for that activity. Now, just to be clear, what was probably happening in that scenario was something trendy, more trendy 20 years ago, is that one of the ways of laundering money was that people with cash who had earned this cash through illicit purposes would use it for earnest money deposits to buy real property. Those contracts would inevitably have contingencies that would excuse the buyer from performing under the contract. The buyer would exercise that contingency, terminate the contract, and get a check back, in the example I just gave you, for the $18,000 of earnest money. So that is how they converted $18,000 of dirty cash, got it into the banking system, and then got a check back. Now, it didn't work. It didn't work for sums over $18,000. But it did work probably pretty well for sums under $10,000. I have not personally seen that as a money laundering technique in a long time, and I would suggest that's for two reasons. One of the reasons I don't think we've seen it for a long time is that over the last 20 years, brokerage firms have shied away from holding earnest money trust deposits. At least in my state, the state of Colorado, there is a tendency for medium and small brokerage firms to allow title companies to hold these funds. And title companies are more sophisticated about these issues. It's harder to pull the wool over the eyes of the title companies, and so that's one reason I think it's declined. And then the other reason is that $10,000 is so much less now than it was 20 years ago. I don't see the use of real estate contracts and earnest money and then the later termination of earnest money as a way of laundering funds so much anymore. So you ask, why the heck are we broadcasting this? And the reason I think money laundering is especially relevant topic now, at least in the state of Colorado, is because for some time now, Colorado has had a legalized medical marijuana business, and more recently, Colorado adopted a form of legalized recreational marijuana use. Because the cultivation, consumption, growing, and sale of marijuana is still illegal under federal law, the marijuana entrepreneurs are not allowed to deposit the proceeds of their operations in the federal banking system. It is a cash business, and that having all that cash flooding around creates a tremendous amount of pressure to introduce that cash into the banking system. And there is pressure to use real estate to do so. So here's just some structures that I think are being contemplated. So again, title companies, there's not a meaningful way for title companies or reputable lawyers to accept this $100,000 and introduce it into the banking system. Because depositing those sums of money will trigger the obligation to report suspicious activities reports, and the people who are trying to introduce the money into the banking system are intending to avoid exactly that. So what else can they do? Well, imagine you have $100,000 of cash. One of the things you could do is find a seller who is willing to accept cash proceeds, close that transaction, and not use a title company, not run the money through the title company. The title company can issue a title commitment, but just because the title company issues a title commitment and later issues a policy does not mean that the title company needs to handle the closing. The seller and the buyer essentially meet at a closing. There is a swap, let's say, of a deed for $100,000 in cash. There's other details, of course, and then the seller has $100,000. And then the reason there's money laundering risk associated with that is now all of a sudden the person has converted, the buyer has converted $100,000 of cash into $100,000 of real property, which that owner can then, that buyer can in turn sell on the marketplace, run that transaction through a title company. The buyer will buy with whatever funds the buyer uses, their own funds, funds that they've borrowed, some combination of the two. Those funds are already in the banking system, and the person who had $100,000 who acquired the lot with cash will walk away from their sale transaction with a check, not for $100,000, right? Because they'll have transaction costs of reselling the property. They might not be so motivated by price, but maybe for a premium of paying essentially $10,000 in transaction costs, they will sell that lot for $100,000, walk away with $90,000 in cash, and have introduced the fund into the banking system. So who doesn't need to worry about this? I don't think the listing broker who lists the property for the person who bought it with cash needs to worry about the resale transaction unless that listing broker is aware that their client bought it for cash. Because if they are aware that their client bought it for cash, then they're arguably part of a conspiracy to convert illicitly earned cash, again, it's still illicit under federal law, into a check. That is laundering. But the money launderers will hopefully be smart enough to hire listing brokers who are clueless about the source of funds that the money launderers use to buy the dirt. I think the people who have more reason to be concerned about it are the people who are obviously trying to launder money. They're sophisticated players. They're lawyered up. This broadcast is not designed for them. It's more designed for the brokers who might help put that transaction together. That transaction for the cash acquisition of the $10,000 lot where the owner swaps a deed for the cash. Arguably, that owner is engaging in criminal activity. Arguably, the brokers are engaged in criminal activity, part of a conspiracy to enable the person with the cash to launder the funds. If you're asked to be involved in one of those transactions, you need to talk to a lawyer in your state. And I'm in the state of Colorado. If you're outside of the state of Colorado, do not talk to me. Talk to a lawyer in your state. But if you are asked to participate in one of those transactions and are inclined to do so, you very much need legal advice to help you analyze, balance, and manage that risk. Thank you for your attention. Hope you catch the next one. Be careful out there.